Can you imagine the ultimate punishment not happening behind prison walls, but right out in the open in the town square for literally thousands to see? Well, that was the reality in early America. Today, it's this incredibly controlled, meticulous legal process. So how do we get from that public spectacle to this very private procedure? Let's trace the pretty dramatic transformation of the death penalty right here in the United States.
Okay, so our story kicks off in the 18th century. This was a time when an execution was, well, anything but private. You got to think of it more like a public ritual, a piece of civic theater, really, with a very clear and yet very grim moral lesson for the entire community.
Just take a look at the size of the crowd in this image. I mean, this was not some small, quiet gathering. We're talking about thousands of people, men, women, even kids, all showing up for what they grimly called the Parade of Death. It was this powerful and pretty sobering community event that was all about reinforcing the social order. Now, right at the center of this whole spectacle was the condemned person. And believe it or not, they had a specific role they were expected to play. Take Rachel Wall. Right before she was hanged in Boston, she delivered this final warning. See, the expectation was for her to act as a penitent, a living, breathing cautionary tale whose last words were like a final sermon to the crowd. It was basically a performance of repentance, whether it was genuine or not. And you can bet this was a highly structured affair. It all started with this big procession from the prison. You had ministers and city officials playing these key roles. A formal sermon was delivered to the huge crowd. Then came that final warning from the condemned. And then, as a final indignity and just another layer of deterrence, the body was sometimes handed over to doctors for dissection. That was the whole shebang, the complete theater of death. So for nearly 200 years, this model of public punishment, it held strong. But as America rolled into the 20th century, the ground really started to shift under everyone's feet. The focus started moving away from the spectacle itself and more toward the fairness of the system behind it. And this long-standing tradition, it was about to face a massive legal challenge. By the mid-20th century, people were starting to ask some really tough questions. The death penalty just wasn't being applied consistently. The decision of who lived and who died often felt kind of random, like it depended more on your race or how much money you had, or even just where the crime happened than on the specifics of the crime itself. The system was seen by a lot of people as fundamentally arbitrary. And this all came to a head in 1972 with the landmark Supreme Court case Furman v. Georgia. Now, here's a really key distinction. The court didn't say the death penalty itself was unconstitutional. No, they said that the way it was being applied, this random, arbitrary system, violated the Eighth Amendment's ban on cruel and unusual punishment, and that one decision brought every single execution in the country to a grinding halt. The main opinion from the court was unbelievably short. It was just this one sentence. But don't let that fool you. The impact was absolutely monumental. With just those few words, the Supreme Court basically wiped out every death penalty law in the entire country, forcing every state and the federal government to go all the way back to the drawing board. But here's the really interesting part. The court was not on the same page at all. All the justices wrote their own separate opinions, and they couldn't agree on one single reason why the system was broken. Some thought capital punishment was always cruel and unusual. But others, and this is crucial, they believed it just needed clearer standards to separate, as they put it, the wheat from the chaff. And that division is exactly what paved the way for the modern system we have today. So because the court kind of left the door cracked open for a new system, states and the federal government got right to work creating one. This whole next chapter was all about fixing the core problem from Furman, that randomness, that arbitrariness. At the federal level, the big response was the Federal Death Penalty Act of 1994. And its entire purpose was to get rid of that randomness the court found in Furman. It was designed to give juries a clear roadmap, a set of rules to follow, to make sure that the ultimate punishment wasn't arbitrary anymore, but was reserved for very specific cases based on clear legal standards. The biggest innovation of this new system was the two-phase trial. Think of it like this. You're splitting one huge decision into two smaller, more focused ones. In the first phase, the guilt phase, the jury only decides if the person is guilty or not guilty. That's it. If the verdict is guilty, then a whole separate trial begins, the penalty phase. And this is where that same jury decides the sentence. And they do it by weighing some very specific factors. This weighing process, this is really the heart of the modern system. Picture the scales of justice. On one side, the prosecution starts stacking up what are called aggravating factors. These are all the reasons why the death penalty is justified, like the crime being especially horrible.
On the other side, the defense places mitigating factors. These are reasons for mercy, like the defendant's mental state or maybe a really difficult upbringing. The jury's job is to literally decide which side of the scale weighs more.
All right, so what specific crimes can even get you into this process at the federal level? Well, the law is actually very specific about which offenses are eligible for the death penalty. So federal law breaks them down into three main categories. First up, and by far the most common, are homicide offenses. Then you have crimes against the state itself, things like treason and espionage. And third, there's this very narrow category of major drug trafficking offenses, which is known as the drug kingpin statute. Now, it is really important to know that while those other categories exist, in practice, the federal death penalty is almost exclusively used in cases that involve a murder. Homicide is still the main trigger for capital punishment.
And this actually points to a really fascinating legal gray area. You see, the Supreme Court has never directly said whether the death penalty for a crime that doesn't involve a killing, like treason or espionage, is even constitutional in this modern era. So while those crimes are technically on the books as capital offenses, trying to actually apply that sentence today would almost certainly set off a major constitutional showdown.
So we've gone on this journey from a public parade of death, designed for moral instruction, all the way to a sanitized, highly regulated legal procedure that's all about guided discretion. The transformation is, undeniable. But it leaves us with one last question. In trying so hard to get rid of the randomness of the past, have we actually succeeded? Or do the same fundamental challenges of fairness and consistency still exist, just in a different form?